So today we are going to discuss about how you can write a problematic question of your contract law course. So the key point to remember is the topic and the term IRAC. So first you need to have a scope of discussion about the topic that is given in the question. Have a sort of discussion there, mention the discussion, mention the statements, and mention the situation. And then you're going into the IRAC part. I stands for issue. You need to identify the issue that is stated in the question, and you have to narrow it down based on the scope of discussion that is given above and the things that you have identified. And you should tackle one issue at a time. Two or multiple issues should not mix into one, and every issue should be stated differently. And there are some examples here, like whether Mina can take action against Mila for breach of contract, whether minor can enter into a valid contract, whether a proposal is communicated to the Mila. So these are the some examples that you can have for your questions. So there you can write similar sentences like this structure and ending with a question mark. And then R stands for rule of law. You can define the law, you can explain the law, and you can discuss about the elements in the law, the cases, similar cases, and the section of the Constitution, some similar cases law. You can mention all of them. So state the rule of law that is relevant to the issue, and if there is a statute, the provision from the act or section must be mentioned. So if you remember any section or act from the previous studies from your contract law course, then you should mention them here. It will work as a bonus for your answer. And if there is any relevant case, the cases should be mentioned here. So if you remember any case that matches with the case of the question, then you can mention it and write down some similarities and same situations. Never mention names in the discussion of law above, and mention them only in the application and conclusion section. So you should not mention names in the discussion of law, rather you should mention them only in the application and conclusion section. And always start by stating the general rules or principles. And lastly, if there is any exceptions or further elaboration, mention them after the main rule has been discussed. So there can be exceptions or further elaborations of the problem that is given to you. There can be some exceptional cases in the similar zone, so you can discuss them and mention them, but you can do that after the main rule has been discussed. You should not mention the exceptions at first. And then coming to the A for application. Next, apply the above law to the facts of the problem or the issue. You can apply the rules of law that applies to this case. As told before, never mention names in the discussion of law above, and mention them only in the application and conclusion section. And lastly, the conclusion. Once the relevant law have been applied to the facts of the problem in issue, you may now conclude the discussion. So once you have done revising all the parts, as you have already mentioned the issue, the rule of law, the application, and lastly when you're writing the conclusion, write it in your way stating what can happen in this year and the facts of the problem, and now you may conclude the discussion as per your answer. Like there is an example here, like Harris lost his camera recently. He advertised in Memplan Daily, a local newspaper, a reward of 500 to anyone who can find and return the camera to him. Govinda, his neighbor, found the camera. He knew that camera belonged to Harris, so he returned it to him. Govinda only knew of the reward the next day after reading the advertisement. Govinda wishes to claim the reward from Harris. Now advise Govinda. So like if we look at the example of the answer, at first we go into the issue, whether Govinda may claim the prize from Harris, or whether proposal is completely communicated to Govinda, or whether there is a communication of proposal. So these are the issues that you have identified from the problem. And now going into the rule of law. A contract is an agreement between two or more parties that is legally binding between them. The principal legislation for the law of contract is the Contracts Act 1950. Under the Contract Act 1950, section 2H, contract is referred to as an agreement enforceable by law. Like as you can see, here are some cases and sections of the case mentioned. So it is better if you can add some sections and similar case scenarios here. The word proposal in the Contracts Act 1950 basically bears the same meaning as offer, and Section 2A of the Contract Act. A proposal is made when one person signifies to another his willingness to do so or abstain from doing anything, with a view of obtaining the assent of that order to such act or abstinence. Section 2B further mentioned that when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. So this is an example of writing the exact thing that is written in that section of the case. So you are given a contract law revision sheet that you sent me. So if you can have a revision of that and take a look at some of the cases and the sections that are mentioned there, then you can easily write this down. Upon such acceptance of the application by the person, an agreement between the parties is created. The proposal became a promise, and the party making the proposal is referred to as the promisor, and the party accepting the proposal is known as promisee. Yes, we discussed about the promisor and promisee part in our previous videos. I advise you to watch all the videos again and have a revision of all the parts. An offer or proposal can be made to any particular person or public at large. If made to a particular person, only that person may accept the proposal. If it is made to the general public, then anyone who meets them, all the terms of the proposal may accept. An example of the case, Carlyle and versus Carbolic Smoke Ball. So in this case, the defendant's company advertised that they would offer £1,000 to anyone who still succumbs to influenza after using the company's medicine according to the instruction for a fixed period. I hope you remember the smoke ball case that we discussed earlier. So they had an agreement, like if anyone comes in contact with influenza after using their products, then they will give them £1,000. And they also had a condition, like at first they have to deposit £100 into their account, and then if they try their products and they get infected with influenza, they have to give £1,000 to the victim. The plaintiff duly used the product but nevertheless contracted influenza. The plaintiff then sued for money. So the plaintiff ultimately contracted influenza, so he sued them for the money. Court in this case held that the plaintiff had accepted the offer of the company made to the whole world at large, and he is therefore entitled for the money. So like this smoke company, they published this advertisement, they published this statement to the whole world. So if anyone uses their product and gets in contact with influenza, they have to pay them the money, like £1,000 as they promised. And proposals also must be communicated to the other party to an extent that the party accepting the proposal is aware of the existence of such proposal in the first place. The fact that the other party has done something which coincidentally appears as if he is accepting the proposal without actually aware of the proposal does not bring any agreement into being. So both the parties have to understand the fact that there is an agreement that exists, that belongs to here, and if one party doesn't know about the contract and the other party claims for it, so it does not become a valid case. An example is the case of R versus Clark. In this case, Western Australian government offered a reward for information leading to the arrest and conviction of persons responsible for the murder of 2 police officers. X and Clark were arrested and charged with murders, but shortly after, Clark gave information which led to the arrest of another person. Y, X and Y were later convicted for the offense, and Clark, who did not commit the murder, claimed the reward. Court in this case refused to grant his claim. It failed on the grounds that his information was given to clear himself from the murder charge and not in reliance on the offer of reward. So there's another case similar to the case given in here, like if there is a promise and some of them is already convicted, so that convicted person cannot claim that offer because he has to first get himself out of this case. He is already a convicted criminal. So now as he has gotten himself out of it, then it's good for him. So the murder charge has been given off, so and it is not reliance to the offer of a reward. See, he is not approved for the reward. And then how you can apply the application in this case, there is an offer made by the Harris, when he advertised in Mempleum Daily, a local newspaper, a reward of 500 to anyone who can find and return the camera to him. Harris made a proposal to the public at large, so anyone who meets the requirement may claim the reward. So this proposal was made at the public, so the anyone from the public who sees this offer and then does exactly what is said, then he is applicable to be given the money. And proposal must be communicated to ensure the party accepting the proposal is aware of the existence of such proposal. In this case, Govinda, not aware about the existence of proposal or the reward made by Harris at the time he found the camera, proposal is not communicated to him. He only knew the reward the next day after reading the advertisement. The situation is similar with the case of R versus Clark. So what happened in the case of R versus Clark? There are two convicted people. One was the victim and one was innocent, and the other one was a criminal. So when the victim and the innocent guy, he made himself out of the charge, and then next he saw that there is an advertisement for a reward. He told them that I am not the guilty person, so the next person that you got, he is the main criminal, but he is not entitled to any reward because he just got himself out of case. And in the similar case we can see of Harris and Mr. Govinda. Like Govinda did not know that there was a proposal that existed, so he found the camera, returned it to Harris, and then the next day he saw the advertisement that there is a reward coming. So then he went to sue him, but it didn't work because a proposal or any contract has to be communicated at first. If the other party doesn't know and one party is aware of the proposal, then it doesn't make it a valid contract. And lastly, the conclusion part. Here you can write what you have ultimately decided. In conclusion, Govinda cannot claim the reward of Harris because the proposal is not communicated to him. He has no knowledge about the reward at the time he returned the camera to Harris. The fact that the other party has done something which coincidentally appears as if he is accepting the proposal without being actually aware of the proposal does not bring an agreement into being. So in the conclusion part, you give your final statement, you give your final advice. So here you have given already the advice that Govinda cannot claim the reward because the proposal was not communicated to him. He was not aware of such proposal that existed. So that's how you end a case. That's how you answer a problem solving case of your contract law question. So you need to remember that at first you need to understand the topic that is given in your question. Then you need to study some of the sections and cases of law that is mentioned in your notes in the part of contract law revision. In that slide there are so many cases, so you can have a look at that and memorize some of them and use it in the questions that are coming to you. And nextly the term IRAC, first issue, second the rule of law, and then application and conclusion. This is how you can answer a problem question totally and gain the potential marks that you can have from your teacher. So I hope this video helped you, and I really wish you all the best for your coming exam. And if there is any question or any problem that you're facing still, then let me know. I'm going to get back to you as soon as possible. That's all for today. Thank you.